is Soha Sayeid. I'm an attorney in private practice with Abney Law Office. My primary, practice fields are workers' rights and civil rights. And before I went into private practice, from about 2008 to 2016, I worked at the Legal Aid Society in Louisville, where I handled, hundreds of eviction cases on behalf of tenants. And I handled evictions both in Louisville and Jefferson County, as well as in like 14 counties around Louisville. So I have experience in both the Uniform Residential Landlord-Tenant Act, which is applicable in Jefferson County, as well as just the statutory laws that are applicable whenever the Uniform Residential Landlord-Tenant Act hasn't been adopted by a particular locality. So I'm going to get into all of that. But I do want to just say I don't do as many evictions anymore, just because since I'm in private practice, I don't want to charge anybody to do eviction work. And I also can't afford to do all pro bono work. So, if I get a referral from anybody to handle an eviction case, I always try to help out, just because unfortunately there are not many private attorneys who have the experience to be doing this work. Primarily, the legal aid organizations throughout the state are the only attorneys doing any sort of tenants' rights practice. So I have an outline here, and I'm just going to go through generally what I'm going to be talking about. And then if there's anything that you would like for me to talk about that I don't mention, I think just put it in the chat, and Josh is going to be keeping track of that so that I can answer any questions towards the end. And if there's any questions that you have regarding what I'm saying that doesn't make sense, just let me know while I'm saying it, and that way I can explain it while it's happening. So there is kind of a lot to cover, but I tried to pick just the sort of more like the hot button topics, or things that come up most often when we're talking about tenants' rights. So I'm going to be talking about the basics of leases, the Uniform Residential Landlord-Tenant Act, which I just mentioned. I'll be talking about breaches, both financial and non-financial, and that is not just from the tenant's perspective, but also from the landlord's perspective. I'll be talking about damages, both from, again, tenant's perspective and landlord's perspective. The eviction process, the timeline. Did somebody say something? Okay, sorry, I don't have my actual Zoom window up. I'm looking at my outline. So if anyone says anything or waves or put something in chat, I'm not going to see it right away. So I'm going to talk about the eviction process and timeline. I'm going to be talking about the eviction court, what to expect while you're in court, post-hearing, appeals, set-outs, and then some resources and information that is up to date regarding what's been happening since the pandemic began. So what I'm going to be starting off with is the typical procedures based on the law pre-pandemic, because I think that is important to kind of establish what the basis is before we talk about what's happening right now. So as I said earlier, the Uniform Residential Landlord-Tenant Act is a set of laws within the broader landlord-tenant laws that are only applicable in the cities or counties that have adopted, we call it URALTA, is like the abbreviation for the Uniform Residential Landlord-Tenant Act. So Jefferson County as a whole has adopted URALTA, and I'm only going to be talking about that today, just because this is a Jefferson County specific training. I know I saw some people who are in Fayette County as well. Fayette County has adopted the Uniform Residential Landlord-Tenant Act, and then there's a handful of places throughout the state that have adopted it as well. The procedures do vary significantly from a URALTA to a non-URALTA jurisdiction, and even within a county. So I live in Shelby County. In Shelbyville, the city, the Uniform Residential Landlord Tenant Act is in effect. However, in the broader county, if you live outside the city, it's not in effect, and therefore the laws are different. So you could have two tenants sitting next to each other in eviction court, and there's going to be two different laws that are applicable to them. I think Bowling Green has adopted it, but I'm not 100% sure. There's a list on kyjustice.org that I believe is most up to date that you can check and see if they have adopted it. So regardless of whether you are in a Uniform Residential Landlord Tenant Act jurisdiction or not, most tenants are going to have leases, right? That is a contract between typically two parties, the landlord and tenant, that describes the rights and obligations between both parties. It's not required. You can have an oral lease, but I think most tenants are going to have some sort of written agreement that says this is the amount of rent, this is the term of the lease, this is where the security deposit is held, this is what the tenant has to do, this is what the landlord has to do, or some combination thereof of those terms. If you don't have a written lease, you're probably going to have some sort of oral agreement that explains, when rent is due, what is the amount of rent, and basically what the premises is. The law applies regardless of whether you have a written or oral lease. So what I'm going to be covering, regardless of whether the tenant has a written lease or not, these obligations, these rules are applicable. So with leases, they can provide additional rights to what the law requires, but they can't provide fewer rights than what the law provides. So an example of that is that if a person has not paid rent, then their landlord is required to give them a 7-day notice of their non-payment and a 7-day notice, which can be combined into one, that they need to pay rent. So if your lease says that the landlord only needs to give a 3-day notice, that's fewer rights than what is available by law. And so the landlord can't circumvent that 7-day notice period by giving a shorter amount of time than what the law provides. They can provide additional rights. So the lease can say that the landlord has to give a 10-day notice, and that will be applicable, and they can't then go and give only a 7-day notice because that's what's provided by the law. So again, lease can provide additional rights, but it can't provide fewer rights than what the law allows. Leases also run with the land. And so if somebody were to buy the property from your landlord, they can't evict you just because there's a new owner. If you have a 12-month lease and you're 2 months into the lease, the remaining 10 months of that lease runs with the land, and it goes on to the new owner, who then becomes your new landlord. So moving on to breaches. So a breach is some sort of non-compliance, some sort of something that either party has failed to do or done incorrectly that is covered by the contract or the law, and that could potentially break the contract. So the most common type of breach is probably a financial breach, so non-payment of rent. That's covered by KRS 383.6602, and that is what requires that 7-day notice that I mentioned earlier. So within that 7-day notice that the landlord says that you haven't paid rent and you must do so within the next 7 days, or I can terminate your lease after the 7th day, the landlord has to accept rent within that time period. So if you go to the landlord on the 7th day with the full amount of rent and or late fees, the landlord can't say, too bad, I'm not going to take it anymore. They don't have to accept any partial payments, but if they do, they can't then on the 8th day go and file an eviction saying that you haven't paid the full amount of rent. KRS 383.675 covers partial payments of rent. So beyond financial breaches, there are non-financial breaches. So there's been some damage done to the property, or there has been, I don't know, some sort of, like there's an additional person who is living with the tenant that's not on the lease, whatever kind of non-financial breach the landlord wants to make up. That's also covered within KRS 383.660, but it's under subsection 1. So for a non-financial breach, a notice is required, but not a 7-day notice. For this, the landlord has to give a 14-day notice, but the cure period is 15 days, which is like this weird, you know, I don't know why it's written like that, but basically your landlord has to say, you have somebody who's living with you. If they don't move out within 15 days, then I'm going to terminate your lease. And actually, they can say they have to move out within 14 days, but if they move out on the 15th day, that's considered a cure, and your landlord can't then terminate your lease agreement based upon that. So you do have the right to cure for non-financial breaches as well. However, if the same issue occurs within a 6-month period after that notice, then the landlord does not have to give you a right to cure, but they still have to give you a 14-day notice, right? So if they give you a 14-day notice to say, you've got to move this person out who's not on the lease, and you know, the person moves out, and then 3 months later, the person moves back in, then your landlord only has to give you a 14-day notice that your lease is terminated, and then can move forward with an eviction without giving you a right to cure. There are, although the law does not require a non-financial breach, or doesn't define what a non-financial breach is, it just says material non-compliance with the lease, courts have regularly upheld that there are some types of material non-compliance with the lease that is not applicable to this law, and therefore does not require a right to cure. So I can't remember if it was one of my cases or one of my colleagues' cases, but a tenant had shot somebody in self-defense, and it was on the premises of where I think maybe they both lived, and the court determined that the tenant who had shot the other person was not required to be given a right to cure that particular breach. So, you know, we argued against that because obviously the person could have said, I'm not going to do this again, although, you know, it was a self-defense issue. So there were more layers to it, but typically the courts are going to side with landlords in most of those material non-compliance issues. We're talking about a tenant's failure to maintain. So there's something that the tenant has failed to do in terms of, you know, damages to the unit, or has willfully caused some sort of damage to the unit and failed to repair it. The landlord can fix the problem and then bill the tenant, and then that billing becomes part of the rent that the landlord can then evict the person for as a non-payment of rent if they didn't pay it. That's under 383.665. And like I mentioned, under KRS 383.675, if the landlord accepts rent with knowledge of a default in the rent, meaning that it's something less than what is owed, or the landlord accepts rent knowing that there is a non-financial breach, that there's somebody living in the property and they still accept the rent, then they have waived their right to terminate the lease for those particular issues. So either the landlord accepts the full rent or no rent. You can't have it both ways by accepting a partial payment of rent. You also can't have the landlord accepting rent, any amount, knowing that there's some other problem and then trying to evict the tenant for that particular problem. The law also includes non-compliance of the lease by the landlord. If the landlord is required to do something by either the lease or some sort of like health and safety issue with the property, and the landlord fails to comply with that, then the tenant can send a 1430 notice, is what we call it, and it basically requires that the landlord cure their non-compliance within 14 days, or the lease will terminate within 30 days. So it's not you have to fix this problem, period. It's you have to fix this problem, and if you don't, then the lease terminates, and if the lease terminates, then the tenant's required to move. So not particularly helpful for most tenants for whom moving is just as expensive, if not more, than paying rent or dealing with like landlord issues. But that's what the law allows. If the breach is the same that the landlord has done within the last 6 months, then the tenant only has to give 14 days notice to terminate the lease, and they don't have to give the landlord a right to cure. A landlord cannot abuse their right of access. So generally speaking, landlords are required to give notice that they're coming in if they need to do some sort of repair or inspection, unless there's some sort of emergency situation like the leaking pipe or something that's causing damage to another unit, then they can come in. However, they cannot abuse that right of access, and tenants have rights to seek relief from the courts if the landlord does abuse their right of access. If there's any sort of damages that the landlord is not fixing, that the tenant has not created, again, you can do the 1430 notice where you say you have 14 days to fix this problem, or there's going to be, or I'm going to terminate the lease within 30 days. This option potentially works well for people who can afford to move within 30 days. But like I said, it's not a great option for people for whom it's difficult to move and too expensive to move. The reason I think that the law includes this is because if you were to move without notice, and if you were to just move without giving the landlord an opportunity to fix whatever issue, and the lease has not been properly terminated, then the landlord can come after the tenant for damages for the remainder of the lease term. So if there is a problem within the first 3 months of a tenancy on a 12-month lease, then you actually have is basically a contract for 1 year that has monthly payments of the full amount. And so although the landlord has a duty to mitigate by trying to rent out the apartment, if it takes them 3 or 4 months to re-rent, then the tenant is on the hook for those 3 or 4 months where the apartment or whatever premises it is wasn't rented for that period of time, if that makes sense. Okay, so I want to talk a little bit more about damages, just because I think that is a pretty, when we're not talking about rent issues, damages are probably the number one other issues that especially tenants have, and in regards to landlords not fixing things that need to be fixed. So just generally speaking, with tenants' obligations under KRS 383.605, a tenant should not intentionally damage anything. They should not disturb their neighbors. They should use amenities or utilities like plumbing, electricity, etc. in a reasonable manner. They're to maintain the premises in as clean and safe a manner as the condition of the premises permit. And that's directly a quote from the law. And they are to follow the landlord's reasonable rules and regulations. And if there are new rules or regulations that the landlord comes up with after the lease is signed, they have to go through a procedure that includes that, it can't just be a new rule that you have to pay more rent. It has to be reasonable. It can't change significantly the terms of the lease. If it has to do with health and safety, there has to be some notice given. And if we have any questions about that, we can talk more specifically about that piece of it. Landlord obligations, that's covered under KRS 383.595. Generally speaking, landlords are required to comply with applicable building and housing codes. They're required to do whatever is necessary to keep their premises in a fit and habitable condition. They're also required to keep common areas clean, supply running and hot water year-round, and heat between October and May, unless there is separate metering in which they are not the ones being billed for those services. If a landlord intentionally fails to provide essential services, then the tenant can supply their own and deduct from rent. They can also seek substitute housing and not pay rent for that period where they maybe had to stay in a hotel. In either case, a written notice to the landlord is required. There is no right for the landlord to cure that issue because of the fact that it's an essential service. And so because it's an essential service, then it's basically considered as an emergency. And although the written notice to the landlord is required, there is no time period that the tenant has to wait for the landlord to fix the issue. Alternatively, a tenant can also seek treble damages. So, if the cost of fixing the issue that was a willful problem that the tenant or that the landlord created and it cost $100, you can seek up to $300 in damages plus attorney's fees. Or the tenant can repair and deduct. This is probably the most misunderstood part of the law because a lot of times people want to repair and deduct the entire cost of whatever it takes to fix a problem, which seems reasonable, but according to the law, it's not. So if there is some sort of damage issue that the landlord is not fixing, then the tenant is still required to give landlord notice, and the landlord still has the right to fix whatever the problem is within 14 days. However, if the landlord doesn't fix it, instead of terminating the lease, the tenant can then get the work done in a workmanlike manner and then submit an itemized cost statement to the landlord and then deduct the cost of that from their rent. However, the cost of that cannot be more than $100 or more than half of their monthly rent, whichever is greater. So if the cost of fixing something was $1,000 and the person's rent was $1,000, the most they could deduct was $500 from the rent. If it cost $50 to fix, the most they could deduct is $50 because that's the actual cost of the repair. And again, it requires notice to the landlord. It requires that they have that they have the right to fix it within the 14 days. And then the work gets done, the cost statement gets submitted, and then the deduction happens. To the extent that people do this, they get some piece of it wrong, like either in getting the work done and then not submitting the itemized cost statement, or assuming it's going to cost a certain amount and then deducting the rent and then getting the work done. So the law does not allow that. It really, unfortunately, is a very strict procedure that makes it more complicated to just get things done. Okay, let me check the chat really quick to see if there's anything that I need to be cognizant of. Any questions? Okay, no. Moving on to evictions. So a landlord cannot file or cannot evict anybody without going through the court process. So there's no eviction through locking somebody out, and there's no evictions through failing to provide essential services. So you can't turn off the heat, you can't shut off the water, and basically have like a self-help eviction is what we call them. The eviction must be approved by the judge and have to go through that process. The landlord must provide those notices with the right to cure, either a 7 or 14-day notice. Landlord must accept the cure within the legal time frame before filing the eviction. Is only an attorney or an owner can file an eviction. You can't have like a property manager filing eviction. That's considered an authorized practice of law. A landlord cannot retaliate against a tenant for seeking code enforcement, for complaining about damages or repair issues, for seeking to start or starting a tenants union. However, if the tenant owes rent, back rent specifically, then you can't use retaliation as a defense to an eviction, and the landlord may proceed with the eviction. All a landlord needs to do to go and request an eviction is to go to the small claims office. And actually, I think there must be a different procedure now because they're not really letting people into the courthouse unless they've got some specific business. But Typically speaking, you go to the courthouse, the district court, hall of justice, and go up to the third floor to the small claims division, fill out the paperwork, pay the fee, file it, and then there is basically the process either goes to the sheriff or it gets mailed to the tenant, depending on how they want service. Typically, it's effectuated through the sheriff. And technically, eviction proceedings can occur within as little as 3 days from when the tenant gets that notice. The eviction complaint, it's actually called a forcible detainer complaint. And I think that's what it still says on the top of the complaint itself. And in Jefferson County, it typically takes up to 3 weeks for the court date from when the person is when the person is served. Currently, eviction court's held online, although defendants do have the right to go to court in person if they can't access the Zoom eviction court hearings. So although eviction court is for like non-payment of rent, financial breaches, non-financial breaches, things like that, rent is not recoverable in eviction court. The landlord has to file a separate small claims process, or depending on the amount, either a district or circuit court action. They cannot get rent through the eviction proceeding itself. They can only get the right of possession. So forcible detainers are considered a special statutory proceeding and a summary proceeding. So a special statutory proceeding means that the entire process is within the statutes, so like the legislative body made law, as opposed to common law or state or case law. And then it's a summary proceeding, meaning that you don't have a right to things like discovery. So in most of the cases that I practice now, like the workers' rights cases, civil rights cases, most of our time is spent doing discovery. We send out written requests for information to the defendants, and the defendants send to our clients written requests for information, and then we do depositions, and these cases can take months, if not years, because you're gathering all of the information that you need to have a trial. And obviously you're dealing with a lot of people's schedules, and so it can take a really long time to go through the discovery process. And so that way, when you do get to trial, you know everything that everybody's going to say, and you know about every piece of evidence that possibly exists. You don't have that right in eviction court. You have a right to a jury trial, and you have a right to subpoena witnesses to that trial. But when you get to trial, you don't know what anyone's going to say. Sometimes you don't know what your client's going to say, but you can't have deposed the landlord or any of their witnesses prior to the trial. You don't get any sort of witness statements or anything like that. Although you have a right to a jury trial, it's pretty rare. I've done 4 eviction jury trials, and I think I don't know very many people who have done more than that throughout the state, just because most people, well, I'm not going to assume why. So I used to ask for jury trials all the time, just because I felt like I could get a more fair trial with jurors than I could with the judge. But most cases that I handled either settled or we had a bench trial. And if I knew that the judge was fair, then I went ahead and proceeded with the bench trial. But there was judges that every time I knew I had a case in front of them, I just asked for a jury trial, and typically that led to a settlement. I do want to say, do not expect that the judge is there to ensure that tenants' rights are upheld. That is 100% something that either the tenant's attorney has to do or the tenant has to do. And if the tenant doesn't have an attorney and says exactly what an attorney would say, would makes whatever legal defense and legal argument that like I as an attorney would say, it's very likely that they're still going to get evicted, and the person with an attorney may not be evicted. Not that I have like 100% success rate or anything like that, but I've seen tenants argue the same thing that I have argued, and because they don't have an attorney, they get evicted. So post-hearing, if judgment is entered against the tenant, then the tenant has 7 days to move. If the tenant does not move after 7 days, then the landlord can seek a writ of possession from the judge. The tenant doesn't get notice of this, and there's not an additional court proceeding for that writ of possession. It's basically handled administratively. And then once the landlord has a writ of possession, they take it to the sheriff, and the sheriff is the one that kind of organizes the set out. So the sheriff will give notice to the tenant that a set out is going to happen. Typically they'll say on October 15th at 9 a.m. we're coming to do a set out. They're probably not going to come out on that date just because they want to make sure that everybody is safe, and so they will very likely do a surprise set out. The timing of that varies. It's usually a couple of weeks after that 7 days has expired, just because of scheduling. And it's not the sheriff that actually does the set out. They're there to keep the peace, but the landlord is the one that's required to provide the people and the materials for the set out. And then going back a little bit, within that 7 days that the tenant has to move, they may also file an appeal. And the appeal must be filed within 7 days. Other types of appeals have more time that they can be filed. So typically a district court appeal or a circuit court appeal, you have 30 days after the judgment to file a notice of appeal, and then much more time to file a brief. For eviction court specifically, you have 7 days to file a notice of appeal, and then 30 days to file your brief, and that goes to the circuit court. Those dates are mandatory, and so if you miss filing whatever, that can get your appeal dismissed without the judge considering any of your legal arguments. If the tenant files an appeal and wants to retain their residence in their premises, then they have to pay their monthly rent into court escrow as it becomes due. If they don't pay their rent, then the landlord can continue with the writ of possession, and the person has to move. They still have their right to appeal, but they don't have a right to maintain the property or maintain their residence in the property if that monthly rent is not paid. And if at any point they fail to pay their rent within that period of time, however long the appeal takes, then the landlord can go and get a writ of possession and get and do a set out even while the appeal is maintained. Now, I guess the landlord runs the risk of setting somebody out who will eventually win the appeal, and maybe they will be exposing themselves to some sort of liability for an illegal eviction. But there's so few people who appeal anyway, and then there's even fewer people who then can seek any sort of damages for any claims that they have if they were illegally evicted after a successful appeal. That landlords mostly will move forward with the set out if the person doesn't pay their rent. Okay, let me take a break before talking about the current situation and talking about resources so that I can answer any questions. Okay, so when you talked about breaches for non-financial reasons, what's the max time period allowed when the person is being accused of the same issue twice? Okay, so for non-financial breaches, the cure period is 14 days notice, but they have 15 days to cure. And then the same issue twice, 6 months. So if you've got somebody who's living on your property who's not supposed to be, and you give notice, and the person gets notice that they need to leave by the 14th of October, and the person leaves on the 15th, then that issue has been cured. But then say on January 1, the landlord says that you've got somebody living with you again, then they can just give a 14-day notice saying that your lease is terminated. And does that answer your question? And then in terms of the actual citation to the law, that is KRS 383.6601. Any other questions? I know I kind of just went through those, but I mean, it's law, so it's kind of boring. Okay. Seeing no questions. So the current situation is that for a while there were no evictions going on because the courts had basically said that no evictions were happening. However, we do know that since I think it was August 1, evictions had been moving forward. Like I said, they've been online, and since September 1 through the end of the year, the CDC has provided that basically evictions can be considered a public health crisis and offered some protections for tenants from being evicted for basically non-payment of rent issues. So what does that mean? One, it means that there is a procedure that a tenant needs to follow to invoke those protections. If they just ignore a legal summons for an eviction, then they don't get those protections automatically. The eviction procedure continues as normal. And then if a landlord really wants to get somebody out because they haven't been paying their rent, they can assert a non-financial breach. Maybe the person has a pet, maybe they're messy, the landlord will make something up to be able to move forward with an eviction. So in terms of resources, I do want to share a couple, and these are to kind of invoke that CDC protection for non-payment of rent. There is rental assistance available in Jefferson County through one particular channel, and then throughout the state there is eviction rental assistance available through basically like a state website. So there's two procedures, one just for Jefferson County and then one for the state. So I'm going to share first the Louisville one. Let me see if I can figure out how to share my screen. Nope, I can't. Okay, so the website is stopmyeviction.org. There's the link right there in the chat. And if you can't go to the website, please do. If not, I'll try to describe it as best as I can, but it is specific to Jefferson County. It has the step-by-step process that people need to do to invoke the protections of I don't want to call it a moratorium because it's really not a moratorium on evictions. It's just some basically minor protections that the feds have now provided. Here you go. It looks like I can potentially share my screen. No, Josh, sorry. Or I think I just don't know how to share my screen. Maybe that's my problem. I don't see an option. Oh, the giant share screen. Okay. All right. Can everyone see that? Well, I can't see everyone, so I'm going to assume unless someone tells me that. Yeah, okay. Okay, so this is the stopmyeviction.org. You see that there are steps here for seeking the financial assistance and hopefully preventing someone's eviction. What I have found when dealing with tenants who are being evicted or going through that process is that it's incredibly stressful, and that to the extent that I can do any of this for them or like walk them through it or do some hand holding, the results are much better than if I just leave them to it. I think there's kind of this like idea that like people should like do what they need to do, or if they like are serious about it, then they will do like the steps that they need to do. But typically people are in such like a traumatic and stressful situation that if you just help them a little bit, it just makes the results so much better. So, you know, help them out. So seeking an appointment with the neighborhood place. And then this declaration is pretty important, the second step here. And maybe it's not gonna let me click on it. Oh, there you go. Okay. And actually, I have a better website for this declaration that I want to share. Maybe. Yeah. It's called homerenterdeclaration.org. This is for everybody throughout the country who needs eviction assistance, but there are declarations that the person has to make in order to seek those protections from being evicted. Okay. So they have to say yes to the following statements: that they've used their best efforts to obtain rental assistance, that their 2020 income is less than $99,000 or $198,000 if filing jointly, or they didn't have to pay income tax in 2019, or they received a stimulus check this year. That was the $1,200 payment that many people received. They have to agree that, well, I don't know what I just did, but I did not want to do that.
Who is it? Well.
Okay. They also need to state that they're unable to pay their rent due to income loss or extraordinary out-of-pocket medical expenses, that they would become homeless or need to double up if evicted, so that they would basically have to like move in with somebody else, thus potentially increasing, I guess, increasing their chances of getting COVID-19. That they will still use their best efforts to make partial payments, and that they understand that their landlord may require payment in full for all missed payments at the end of eviction protections on December 31st. There's also a tool that the landlord can do to be able to kind of participate in this process, but I don't want to get too much into that. But this declaration is pretty important. From what I understand, if the tenant has submitted this declaration, but even if they haven't gotten approved for any sort of assistance at the time of their eviction court hearing, that most attorneys are foregoing a set out, seeking that eviction judgment because the person has like moved forward with doing something to protect themselves against an eviction. See, the next thing I want to share, if you can see all my windows that I have open, this is just how I live my life. I'm sorry. So this is one way of getting information for non-Jefferson County residents. So basically everybody who does not live in Jefferson County but lives in Kentucky goes through this procedure. It still requires the same declaration, but it's a little bit, it's a little bit of a different process, and the pool of money is different as well. I was going to do primarily Jefferson County, so I can't talk too much about this particular non-Jefferson County procedure, but like I said, different pool of money, same general process of needing that declaration. Okay. one other thing. So if you Google Kentucky Revised Statutes and come to the legislative page, you're going to find like a list of all of the statutes of Kentucky. The landlord-tenant statutes are contained at KRS Chapter 383. However, the first many statutes are not related to the Uniform Residential Landlord-Tenant Act and therefore generally inapplicable in like Jefferson or Fayette County. It's not until you get into this like 300 range that you find things that are applicable. And then the Uniform Residential Landlord-Tenant Act is applicable, or it starts at the 0.500 and goes into 780, 715. So these are the specific laws related to Jefferson County. A lot of times you will find landlords who will look into, do like a general search, and they will find, you know, something that says that basically recovery of rent in absence of a written contract, you know, that the evidence of verbal contract, or the evidence, let's see, basically they can recover reasonable satisfaction for the use and occupation of land through a different, like slightly different procedure. It's not applicable to a URLTA jurisdiction. Only these 0.500 to 715 statutes are applicable. And then I think that is it. We do have a, I guess like the CDC declaration, which maybe I already showed you. Yeah, that if you go to like the KY Equal Justice website, you can access as well. Okay. Let me pause that and go to the chat. So does the court have to receive the declaration for it to be valid? Yes and no. It's probably best to go ahead and have a copy of that available to present as evidence, but like follow the procedures for like everywhere that the declaration like states that you need to send it. Sorry, I'm just realizing that you can only see the Stop My Eviction site the whole time. Let me go and put some of these links on in the chat so that you all can access them. So that is the legislative website where you have the forcible detainer and URLTA laws. And here's the, I sent the stopmyeviction.org. Here's the statewide link. I think that's all. Okay. What other questions can I answer? Did I really cover everything?
Yeah, I think so. I think we can take questions now. Soha, if you're ready.
Yeah, absolutely.
Okay, so everyone feel free to jump in with questions. In the meantime, I had a question about set outs. Is there any requirement, you said something about, typically they do surprise set outs. Is there any requirement for the tenant to know exactly when those shares are coming and to be able to obtain that information?
No. Basically, the sheriff can schedule a set out anytime after the 7-day period from the judgment has happened, is completed. So like you can expect that it's not going to happen within 7 days of having the judgment, but there's not a way of like, I guess, knowing exactly when, and they claim that they can't due to safety issues. I guess they're afraid that, I don't know, I guess like, well, I guess they're afraid that organizers are going to show up and make a big deal out of a set out. But the idea is that because it's a safety issue, they're not required to let the tenant know exactly when they're coming. See another question going over the 1430 notice. So there's two like 1430 notices. There's the one that you can give, that the landlord can give to you, that says, you have 14 days to cure whatever non-financial issue that you have committed, or well, that's not the 1430, sorry. It's from the tenant to the landlord that says, this is broken, or this is a problem. You have 14 days to fix this issue, or within 30 days, I'm going to terminate the lease. There is a leaking roof, and if you don't fix it within 14 days, then on the 30th day, my lease is over. I'm going to move, and I'm not going to owe you any rent. So that is the biggest thing. It's there's no requirement then that the person have to pay rent for the remainder of the lease term. Did that answer your question, Celine?
Yeah, I'm kind of just wondering, like, if there's only specific things that you can make that type of complaint against, as far as giving them 14 days, because I have a client whose roof has been messed up for over a year, and I've never known really how to navigate that.
Yeah, so there's the essential services sort of issue, where if it's like hot water or electricity or heat, those don't fall under the 1430 notice, just because that's something that you need done quickly. But in terms of what the landlord's obligations that are covered under that, the